Hi there, this is Jonathan Ginsberg. I'm a Social Security disability attorney, and today I'd like to answer the question that I get from clients at hearings, and that is, why did the judge send me out for a post-hearing consultative evaluation? The scenario is this: you go to a hearing, we present our evidence, and the judge basically says at the end of the hearing, I don't think I have enough information. I want to send you out for a consultative evaluation. You're going to get notice in the mail in 2 or 3 weeks. Make sure you go. And post-hearing consultative evaluations are very similar to the ones that are done at the administrative level, where Social Security sends you out to either a physical exam or a mental health exam with a doctor on their panel. This is simply done by the judge. It's the same panel, the same people. And basically the reason the judge is doing this is that he or she does not feel that he has enough evidence to make a decision on the case. Now realize, in Social Security, the disability judge has an obligation, and actually Social Security in general has an obligation to develop the record. Now this does not mean that they have to create a huge record. They just need to have some evidence, and if the record that's there is contradictory, or, which is more common, the Social Security had not previously sent you out for a consultative evaluation, the judge will want to have documentation to support whatever way he or she is leaning. And again, you can't always tell. Sometimes a judge will send you out for a post-hearing consultative when he wants to grant the case but needs more evidence, or sometimes it's to support an unfavorable decision. We just have no way of knowing. What I will tell you is that once the written report from the post-hearing consultative evaluation comes back, I'll have a chance to look at it and to make comments and to write a post-hearing brief. But normally, if those post-hearing consultatives are against you, that's not a real good sign. You're probably going to lose. If they're for you, if they show a severe impairment, then you're probably going to win. Now, this also means that you've got a little bit more time to develop the record on your own. So in other words, if the judge sends you out for a post-hearing consultative and the whole process takes 5 or 6 weeks between the time you get the notice and you actually go to the examination, and the judge will actually read the report, you may have 5 or 6 weeks. And so if you go to your own doctor and we can get a supportive functional capacity form, that can also be helpful in turning the tables and maybe winning the case. So this is sort of a second chance to develop the record further. Again, the judge will do it with the Social Security consultative evaluation. You can also do it with your own doctor. Final point about consultative evaluations, and this applies either before or after the hearing. My experience has been that physical consultative evaluations, those that are done by doctors to evaluate your physical capacity, usually are done by industrial clinic type of doctors, the same people that workers' comp insurance companies use. These are rarely helpful. So if it's a physical problem, the judge sends you out for a consultative evaluation to figure out your physical capacity, it's probably not going to turn out very well. On the other hand, mental health capacity evaluations with a psychologist or a psychiatrist usually will come back with something going on. So those typically are more helpful, although not always, but they're usually more helpful. So there's a better chance that the doctor, the psychologist, psychiatrist will decide that there's something going on significant enough that may support a favorable decision. When all is said and done, of course, you're much better off with treating doctors that you've seen for a long time, you've had a relationship with, as opposed to consultative doctors that you see once for Social Security purposes that don't have any kind of relationship with you. Again, if you have no money, if there's no other choice, then the consultative doctors may have to do it. And I've won cases on consultative physician evaluations, but you're much better off with your own doctor, with a long-time treating doctor. But that's why a judge might send you out for a post-hearing consultative, and that is to better develop the record. Any questions about this, please let me know. Please also give us a thumbs up on YouTube and a like on Facebook if you found this video helpful, and let me know if there's any other topics that I can talk about. Thank you very much.